Good afternoon, members and our listeners today. My name is Tony Kiregaland, your host for Lego Tech Dialogues. And today we are honored to host what many of us call the grandfather of intellectual property. The guest we have today is one who does not fear to stake his leg in the murky waters. Is one when everybody was chasing mortgages, land transactions, he'd said, wait a minute. I'm not going to wait to have startup companies in Uganda before I think about IP. I am not going to wait to have innovators here before I start focusing on intellectual property, copyrights. The advocate we are hosting today is a mother behind a number of our laws in the intellectual property ecosystem. Friends, let me have the honor to introduce to you the already popular and known to many of us, Kenneth Muhangi. Now, Ken is a very enviable character, and you like him and hate him in equal measure. I would need a full day to give a full brief about Ken. But for purposes of this discussion, I will try to limit, summarize these many pages of his bio to what I can manage to read. For those of you who may not know, Ken is an award-winning advocate, author, Lego trainer, and thought leader. He has contributed to key initiatives such as drafting Uganda's Data Protection and Privacy Act, advising on ICT integration and AI policy, and supporting Uganda's National Development Plan goals through IP and digital economy strategies. He is frequently ranked in directories like Chambers Global for his IP and corporate commercial work, and has received honors such as Africa's Male Partner of the Year and recognition as a leading IP lawyer. Ken is not selfish. He goes ahead to share this knowledge on as part of his practice. He serves as a lecturer in intellectual property and is a former head of IP at UCU. He has lectured cyber law at Makerere University and conducts training for lawyers and professionals. Ken holds a master's degree in international commercial law from the University of South Wales and a bachelor's from Uganda Christian University and a diploma in legal practice from Law Development Center. When you are given opportunity to describe Ken, I can assure you we may need 1 hour in addition to our usual hour. And I'm not yet to do that. And before I call upon Ken, today we want to have a very frank conversation. Many of you have written and requested. It says, look, Lego Tech Dialogues, we are having so many young men and women who are seated on their computers, coming up with all kinds of innovations. But there is a problem. And the problem is that, they do not know how to protect what they innovate. They actually do not understand the laws that are supposed to protect them. And you, the lawyers, have left them behind because you are focused more on what we call the traditional practice. So we are in the millennial generation, and the current generation is in the Gen Z generation. As we are thinking of buying land in Nakasongola, like our great-grandfathers, they are thinking of buying shares in a startup of a colleague. And there is no better person to have that conversation with than Ken. Ken, you're welcome. Please say hello to our listeners.
Good evening, listeners, members of Uganda Law Society, the public, everyone who's watching. Tony, thank you so much for having me and for that introduction. You're an advocate that I respect, and I was looking very much forward to sitting with you and having a conversation that perhaps we can be able to look on later and say, these guys were actually talking about things that were meant to help our lawyers and also help our country get to where it needs to go. So it's an honor and a pleasure to be here, Tony.
You know, Ken, I've given a description of you. But when I told a number of my friends that I will be hosting Ken, one of the things they told me that you do not know Ken and you can't describe Ken because Ken is a man of many flowers. And they will be very glad to know who is Ken from Ken's mouth. Thank you.
I'm a human being. I am not an alien, first and foremost. I think it's very important to make that distinction these days with the claims that the Western world is making about whether we are alone. But beyond that, really, I would say that I am, I identify as a Christian, and that is a value that I take into my life, into my work. And beyond that, I am also someone who is intentional about my emotional and mental well-being. I am an ardent meditator. I focus a lot as well on my health and on my wellness. And of course, seeing as we are here having a conversation with advocates, I am an advocate and I practice law. And so beyond that, those are other things we can discuss away from a setting like this. I think that is who I am overall. I am a conscious living human being who is intentional about the practice of law and also about living life in a meaningful way.
Wow. Now for the admirers of Ken, I think I've cheated for you the exams. You want to be a Ken, then learn to meditate.
Yes.
You want to be a Ken, then learn to think about your mental health. Yes. You want to be a Ken, then learn to love your God.
Yes. 100%.
Yeah. Ken, when we thought of the topic to discuss, we came up with so many topics, and our listeners, rounded on one topic. Normally, when we get these topics, we share it out to the target group. And for this particular topic, we were targeting people who are running, who have startups, people who are into digital lending, people who are developing payment systems, people who are innovating. And hence the topic, innovate or imitate.
Innovate or imitate.
Striking the balance between right IP, protection, and Fintech innovation. And the background behind the topic was that many of our innovations are derivative in nature. When we say derivative in nature, we mean there is a payment system I've heard about in Zambia, in Ghana. I come here, I replicate it. Okay? So that creates a very thin line between infringement, between patent attack, and so many potholes within your ecosystem as an expert. And it also brings in issues of whether or not people should go open source or people should have their code at the back of their bag. It also brings in issues of balancing. How far can I go? What can I protect? What then can the law allow me to protect? What doesn't allow me to protect? And unlike my previous discussions I've had of question and answer, this is a very special area of practice which many advocates have not enticed themselves to. And because we haven't done that, sometimes we have thought that people in those areas have been very selfish. And when I called you, I was very delighted when you said, whatever time, I'll be there. Thank you for coming.
Thank you.
So I would want to have this conversation in a thematic manner, because it's not the usual conversation. It's not a practice area that people have a lot of knowledge about. So I will leave these questions, and I will try to structure it in a manner that creates you latitude to discuss from a broader perspective. For starters, to any ordinary person who is a non-lawyer, when you talk of a copyright, when you talk of a patent, what do you mean, basically? Because I am a young man there, busy on my computer, and somebody is telling me, you need to patent your things. You need the copyright. I don't know whether I fall under a musician. I have no idea. Just give us a brief background to set the ball rolling about your understanding of this general topic so that our listeners are able to get a footing. Thank you.
Now, as a teacher, I usually answer questions the long way because I feel that it's important for people to understand context with every question. And but I will start with first clearly defining what a copyright is and what a patent is. So a copyright is a right that protects any literary or artistic work, any expression of any work that I would say has an element of creativity, but from a perspective of drama or literature, or of course now it has also extended to computer programs, but even those have that literary aspect or element. So if you reduce anything, any idea you have in your mind, and you reduce it into tangible form, which can be in form of a book, can be in form of an art piece, can be in form of something that you can actually see or touch. And now we are seeing as well that, or we've seen for a while, that music or the arts or film could be also reduced into phonograms, into CDs, and many of these other devices where we're able to keep this content. That is protected by the law of copyright. For a patent is a solution to a technological problem. So think of any device, any article, any process that has solved a problem in the area or field of technology. That will more likely get a patent. And so maybe for lawyers, the key distinction between the two is that for copyright, for you to have infringement, you must have that direct copying. That I have a piece of work which I have produced here, and then someone then copies that piece of work exactly the way that it is here. I have a design, I have a song, I have whatever it is, and someone copies it and creates something that is similar or the same as what I've already created. With a patent, which can be, you can have a patent over a product or over a process. And so it doesn't matter whether someone has directly copied what you have created. What the law looks at when you look at patent infringement is that someone has tried to do something the way that you have done it, or someone has created an article the way that you have done it. So patent law gives you, I would say, a much wider scope of protection. And that's why many industries, for us to understand why or how intellectual property is important. If you look at the Western world, the countries that we look at as the titans in technology development, they grew as a result of innovators within their private sectors, creating tools, creating new ways of doing things. And those, since they had the protection that no one could be able to produce anything like that, that gave them the latitude to continue to innovate, to continue to create. But also, since it is for a definite time, that after that time, that knowledge goes into the public, and then other people can be able to build onto that body of knowledge. So it is that reward system of intellectual property that allowed these economies to grow as much as they have grown. And I feel that, I hope that is something we shall be able to discuss later. That is because we hadn't paid a lot of attention to intellectual property. I feel that because of that, it was difficult to be able to encourage Ugandans to create. Maybe, of course, there are many other reasons, which I hope we shall be able to talk about. But overall, those two rights, that is how you're able to define them. And they're important in making sure that we continue to create or to produce in our beautiful country, Uganda.
Wow. Beautiful, beautiful words of my brother Ken. For those of you who never knew what copyright means, patent means, now there you are. Thank you for setting the ball rolling. Now we know what we are talking about. We know where you're going. Ken, we decided to structure this into five thematic areas.
Okay.
We are going to be looking at IP for Fintech innovation in the perspective of Ugandan context. That will be one theme.
Okay.
Then we are going to be looking at the Copyright Act and its application to the Fintechs. Okay. Because one of our key areas we are focusing on and where we are directing lawyers is the Fintech industry. There's a lot of digital payment systems that are being developed, but these young men do not have people to guide them. You and me know that now and again, you are having issues of somebody who has developed a payment system and he was not guided by a lawyer, and then before you realize, somebody has taken up the system. It's working elsewhere, and they have even locked him out of the system. So that's why we are looking at it from that perspective. Then we are also going to look at the amendment bill. Okay. And then we are going to be looking at the regulatory intersection. And then finally, we'll see how we close this up. Okay. So I will try to bunch these questions. These questions normally come from our listeners. So when we throw out a topic to a target group, they send these questions. So you'll allow me read, okay, so that we are able to answer to the expectations of our clients. Number one, that's Uganda's Copyright and Neighboring Rights Act was passed in 2006. This is the same year MTN Uganda launched mobile money. The entire Uganda Fintech ecosystem that we are talking about today did not exist when the law was written. How fit for purpose is it right now for a founder building a digital lending or payment product in Kampala? Number two, if I'm a founder in this room and I've just built a mobile credit scoring app, what in my product is protected under Uganda's current copyright law and what is absolutely not protected.
Okay.
And lastly, in that theme, the amendment bill was passed in March 2026 and is awaiting presidential assent. The headlines focused on musicians and royalties. Is there anything in that bill that a fintech founder should actually care about? Thank you.
Those are good questions. I will start with the first. Tony, you'll help me repeat one by one so that I can be able to tackle each. Yes?
Yeah, sure, yes.
Yeah.
I will be able to do that. Number one is Uganda's Copyright and Neighboring Rights Act was passed in 2006.
Fit for purpose.
This is the same year MTN Uganda launched mobile money. The entire Uganda Fintech ecosystem that we are talking about today did not exist when the law was written.
Yeah.
How fit for purpose is it right now for the founder building a digital lending or payment product in Kampala?
That's a very good question. We say that laws should be able to stand the test of time. Number two is that laws should also be able to reflect what is happening in society. And thankfully, and this is something which not only surprises but amazes me, if you look at how far Uganda has developed in many respects, where we are respected more is actually the laws that we have. Being that although, of course, we borrow or we have copied our laws or we received our laws from those who colonized us, that is before we gained independence, when we had the reception clause. That's how we got many of our laws. So that law that version of that law, that was 2006 when we had the Copyright Act. And for many respects, I would think that even now with amendments, which we are going to talk about, the law is on the grander scale of things, okay. Why I say that is that for a right like copyright, first of all, the law has already established it. So once you develop a system, once you develop any network or whatever it is that you're going to develop, you know that you're already protected. So already on that front, the law is fit for purpose. Secondly, is now it is even easier to be able to register copyright. In the past, the biggest hindrance was that cost for gazetting, etc., that made it a lot more expensive. But now that cost has been waived. So that is now cheaper to be able to register copyright. So again, that did not require an amendment of the law. The law was still as it was. It was, okay, maybe you'd say that on the regulation side or rule side, but really it was a procedural amendment, which I would say is an alignment more than an amendment. Because if you're amending, I would say that amendments now that we have in our copyright law, those are real amendments because they change or add to or speak to some fundamental questions regarding how intellectual property should work or copyright should work. Now, for a developer of a mobile system or any system that's used in that regard, I would think the law is okay. Where I would say that we might need a little bit more amendment or discussion is if you are looking at your systems that are now speaking more with other systems. And now, so this is a much deeper, wider discussion. Should software remain as something that is subject to copyright? Or should we look at the more novel applications? Maybe those ones are the ones that we should say perhaps we should advocate more for utility model protection or for patent protection. And so maybe that would encourage Ugandans to be able to create other iOS, an iOS system or to create an Android system, but that would be important within the fintech space or sector. The challenge is that the space as it is, there is little room or there's little room to be able to innovate beyond, at least if you're looking at the core systems that have been created. That if you're going to create any system, let's say a system that's going to carry out or effect any payments, the code that underlines that system is code that would have existed, like you're saying, mobile money started in 2006. So if you're going to innovate, what you're doing is making the system work maybe smoother, work faster, work better. As to whether those amendments or those additions would be considered novel or would be considered some that would be able to get patent protection or utility model protection, I would say that that's why, as advocates, it's important for us to be able to talk to these innovators and say that, by the way, do you know that for you to be able to get a patent, you must create something that's novel? You must create something that has what we call inventive step, that leap in technology.
Yeah.
It must have that industrial applicability. That if you're creating this system, rather than, and I like the topic, imitate or innovate.
Yeah.
Rather than imitate, know that you may be limited in application, being that how will you be able to create a system that is novel, even if you have copyright in it, because once you've created it, of course, you'll have copyright in it.
Yeah.
But if you're looking at the practical application of that copyright, how will you stop someone from being able to replicate the same idea of your system? What evidence will you present in court to show that they had access to your source code? Ultimately, they'll look at your system and reverse engineer it.
Yeah.
So I would say for me, the more meaningful application of the law when it comes to innovators would be if we taught them about what it means to create systems, that if they created that system, if it was interoperable, that it could be able to connect or network with other systems, and it was complex in that way, then perhaps it would be able to get a patent or even a utility model. If it did get a patent or a utility model, then that particular innovator may have a higher degree of protection, being that now you're not looking at direct copying, but if another person has tried to create a system that works like yours, then you're stopping them from being able to do that. But if you're also speaking about the wider consequences, maybe of being able to limit or restrict such technologies in the context of Uganda. Now, depending on where you're sitting, if you're wearing an altruist hat and you're more interested in how Uganda will be able to develop, should we limit or restrict systems, or should we make it so that they're more open source so that you have more people being able to develop? If you're trying to encourage Ugandans in universities or in other hubs or centers to be able to create, should we make it so that those who create, we ring fence and hide you on the side? Or should you actually encourage them, no, create, let the systems actually be okay? Where perhaps we can be able to strike a balance is that if you've created a payment system or app that is unique, then do get whatever protection you're able to get, but let it be so that it is easy to be able to connect that system to another system. Or let it be so that ultimately some of the components of that system are also easy to for another innovator to be able to replicate. So it's a much wider discussion on where, because if you're looking at it from the context of the advocate, also in terms of work, there is still a lot of work in that entire process. Being that as an innovator, although you've used open source and you're not actually copyrighting or patenting the system itself, but you're copyrighting or patenting aspects of the system. And I think now that was the second question you're asking. Someone develops a mobile scoring tool. I like that question, because then now we are thinking much wider, not only from someone creating a platform that's going to affect payments, but they are innovating around systems that can work well with that mobile payment system. So if that system has already existed and they're copying it, like you've said, from Ghana, from wherever, it's difficult, like I've said, in the world that we're in, to say that you can develop a completely novel system, seeing as, these systems have been there for a while, but also for a system to actually be better than another system, that code has to be elegant. It has to work in such a way that me, the user, I feel that there is a big difference between me using my online banking and using my mobile money. That it is easier that when I am going to make a transaction, it is easier for me to go to my mobile money or to this payment application than using one or the other. So for these other solutions that can supplement the actual system, that's where it may be easier to be able to have a lot more registrations. So there's many components of IP. Let me use IP rather than using copyright or patent. Because in a mobile scoring system, you will have a trademark in the name, if it is a unique name. And so you will have copyright in the system, like I've said, or even if you've chosen not to have copyright in the system, you'll have copyright in the database, being that you're actually collecting a lot of data or information about people, and that database also has its own right. Beyond that as well, you find that if there are aspects of the system, like I mentioned, that speak to other systems, then you can also have separate rights that arise from those particular components that you have added to. Let's say you create a device that's able to allow a company to actually integrate that mobile scoring application into their core network. Then you get a utility model for that. Or you create a card or device or whatever it is that's able to store that information. And then you have a utility model, or you have more copyright over that additional piece of tech that you have actually created. So from a mobile scoring system, you'd have a trademark, you'd have a copyright, you can have a patent, depending on, like I've said, if it fits those three ingredients. You can have a utility model if it has that aspect of novelty and industrial applicability, but doesn't have that second step or that second aspect of inventive step. So those are the different rights that I can think of at the moment that would that an innovator can be able to get, and all of those lawyers can be able to advise innovators on how to register or protect those rights.
Well. Ladies and gentlemen, we are having Kenneth Muhanji, partner with KTA, and I'm your host, Galan Tonekire. Can you unpack a very novel area, like your conversation? And for me, my take home to the innovators, the lawyers, how do you strike a balance? Because you are not reinventing the wheel.
Yeah.
And whereas the law came in existence before this massive innovation, because you realize that the law comes in place when the total number of digital phones, for example, smartphones, was an average of 3.5 million. Now we have tens of millions of mobile phones and smartphones for this matter. And that has been a springboard for innovation. And the question, like you're saying, of is the law fit for purpose? And I think for lawyers and innovators, yes, the law has been unpacked for you. You fit in. And I think what you're advocating for is that innovators should not be rigid, because we are not reinventing the wheel in the current artificial intelligence system.
Yeah.
And from where I sit now, you realize that not long ago, when somebody had this source code,
it was gold.
It was gold. But now, AI has taken that away. Yeah. So I like your school of thought that we should strike a balance. We should not keep our own knowledge so tight. The innovation should be flexible in a way that my innovation can easily be compatible with your innovation to be able to make Agre's innovation create a system. You know, if I am developing a mobile app, that is going to be sitting on my phone. I should develop it in such a manner that it should be able to integrate with ease with a telco, so that the API plugs in with ease. And the same should be able to integrate easily with the bank. And you can't do that if you are gatekeeping. If you're saying no, because ultimately there's going to be some giveaways. And the question, I think, for purpose of this discussion is, how are we safe when we are doing these giveaways? I think, Ken, what you're trying to say is that you are still safe, because there is the novelty part of it. You are able to go ahead if it is for industrial use, and the lawyer guides you to register a utility model, something like that. And bottom line, you're not reinventing the wheel, but you will still be protected within the law. And that was one of the purposes of this discussion, because people, innovators of these payment systems are like a deer in a highway, flashed with lights. They don't know where. Should I keep my source code so tight? Should I be flexible a bit? but I'm also praying in waters full of crocodiles. I have had so and so when he tried to be open with Teleco X, he ended up going back at the next day and they say, we don't need you. We have our own system. And I feel they took my system. So this conversation is really very, very important, and it eases the conversation. And I think for the lawyers also, this is an opener, because you show us areas of practice. Yeah. The lawyers who are focusing on other areas, there is bread here. Yeah. Uganda is among the fastest growing innovation hubs in Africa. I think we are third after Nigeria, or third or fourth, something thereabout. So it's really a big area, and I'm very glad that you managed to find time and come and speak to us. And that takes us to our next phase of questions, Ken, which is...
Wait, I'd actually just wanted to add something to what you were saying.
Yeah.
You see, like, if you're an innovator, that question of how should you create your product, how should you create your system?
True.
How does it speak to other systems or networks? Like I said, that also extends to, can it also be, can it operate in a live environment? There's a client we helped register utility model called Jaguza. This innovator created a device. It was a very simple device, but it operated with what we call IoT, the Internet of Things. Being that you have a mobile device that then connects with a particular system that can then connect with other systems or networks. And so what that system did, or what his device did, was you could put it on the ear of an animal, and it then sends data to a veterinary doctor, however you want to get the data, to basically treat your animal remotely, because now they can be able to take the vitals and be able to do that. Now, for an innovator like that, the system itself that he has created may have been based on something else, but because the system has now been utilized in a practical manner, being that you have created a practical device, it was able to get a utility model. So ultimately, and this is a discussion we're also having with a few other colleagues, as lawyers, what is our role? Is our role only that an innovator comes to you and that is when you are relevant, when they're saying go to URSB or go to whatever? Tony, we're already talking about this, how now these regulators have automated their systems such that this information is now out there. Someone can be able to do these things on their own. I feel that time immemorial, the role of the lawyer has been to facilitate that facilitation. Now we call it Gambanogo when we're talking about our... But if you're looking at it from your client, be the Gambanogo from the perspective that you are advising a client that if you're going to create a system, think about it, this way. Like I've said, if a client was come to you at the beginning when they're conceiving an idea, a lawyer, that is really the best time to go to a lawyer. And even you as a lawyer, that is the best time to be able to interface or interact with your client, because then you're giving them practical advice as to how they can go about finalizing their innovation, what aspects, like I said, they can be able to focus on. But even beyond that, when we're looking at the work that is involved in a process like that, you see that two areas work well together: intellectual property and what we now term as tech law. You cannot have one without the other.
True.
Being that if you create like that mobile scoring system, like you have said, it is going to require terms and conditions of use. It is going to require advice on how data protection is going to be handled. So as a lawyer, you can be able to prepare or handle those particular aspects, or you can focus on the intellectual property side, and then you go to Tony and say, Tony, you focus on the side of being able to advise on the data side. Beyond that as well, you as lawyers, our tool of trade, which I feel we don't see it as a tool of trade, our networks. If you go to any lawyer's phone, they will have actual contacts that you may require in your area of business. Now that is a very key tool of trade for a lawyer that is in the innovation space. Because then if an innovator comes to you with a product, maybe you have one of your other clients, or you have a colleague that has another client that could be able to utilize that particular system. So why don't you broker that transaction? Why don't you be able to advise on it so that they're then able to utilize their particular system, but while you're also earning fees advising on that particular project? So there are many ways, and all of that. That's why I've said IP is really at the bedrock of any functioning society, such that when people are innovating, all of these other jobs are now created, all of these other roles are now created as a result of that synergy that can happen as a result of a lawyer thinking not just as someone who's just going to register, to help someone register, but someone who's going to facilitate the transaction from the beginning, from when this particular innovator has conceived the idea and how they should be able to structure or commercialize. That is the word I wanted to end with. How do our clients commercialize their intellectual property? And they can only be able to do that if they have the advice of a lawyer.
Can you pull out something really, and I want to pick a recent example which we had. Many times we have walk-in clients, and as a tech law firm, for some reason, you get a walk-in client. Many times these are innovators, and he's coming and saying, I want to draft for me a partnership agreement. I said, okay. There is this guy here, he's from Kenya, he wants to partner with me, we want to do a merger, we want to, that's all I need, and I want you to bill me for that. And why I think this conversation is important is that the innovators, they sit in their silos, and I think the time they need the lawyer is when they want to register that utility model.
Yeah.
And the conversation here is that let you involve a legal practitioner from the basics, because you're dealing with a number of things. Number one, you are collecting data.
Yeah.
Now, there are laws that protect data.
Yeah.
There are privacy laws to this effect. And big tech companies are actually finding challenges. And they are paying heavily for simply playing with data. Just a few days ago, we were having a conversation about how Meta was fined $5 billion for giving deceptive consent to take US citizens' data. We're giving an example of how Meta Group and WhatsApp in Nigeria were fined $200 million for taking data without consent. We were looking at how, a tech company, I think it is still Meta Group, where the European Union fined them 1.5 billion euros for taking data for Europe and sharing it to the US. And they were saying, look, we don't trust guys in the US. They could be surveilling us. Now, why am I bringing this picture? I want to bring this perspective to an innovator, to a person who is developing a system, and you think you do not need a lawyer. And this system is collecting data. And you do not have a data collection certificate or license. Now, these are conversations which a lawyer will be able to guide you from the time go. You do not want to have this very good innovation. And then some person tomorrow comes and says, hey, wait a minute. You got my data, and I'm getting to realize that you are selling your your product, your innovation to a Kenyan guy, and it is going with my data. And you're in the middle of nowhere. You are in the struggle. So I think lawyers ought to get interested in this area, but also innovators of these systems ought to work with lawyers. And maybe the other thing from a lecturer's perspective, I think I would want you to clear this air. There is this illusion of these innovators. Lawyers are very expensive. I am just a startup. If I bring a lawyer on board, then he's going to ask me for a lot of money. Then where will I move? I think, Ken, from your angle, and I've also seen it my angle here, we help develop, these people, because we all know that they are startups.
Yeah. Yeah.
So they don't have that. They don't have that $100,000 you're looking for at the instant.
Yeah.
But when you grow with them, that $100,000 will definitely come through.
Yeah.
I really want to thank you for highlighting that. And that takes us to our next phase of questions. You will allow me, I don't want to give my own questions. I want to give the questions that have been suggested by our listeners. And that's our next theme is the Copyright Act and its application to the fintechs. And question 1 is the section 6 of the Act says ideas, concepts, procedures, and methods are not protected. That sounds like it covers literally everything valuable in a fintech company. So what exactly does copyright actually protect for a fintech founder, and is it worth anything practically? Number 2, section says employer owns the copyright in work created by employee in the course of employment. But most Ugandan fintech MVPs are built by freelancers and campus developers with no written contract. Walk us through a legal position of a founder who discovers during a Series A due diligence and their core code base was built by the 3 developers who never signed up an IP assignment. What happens? I love the fact that I think this came from a student. You know, these guys.
It came from a student or a client.
Sure.
This is real billable work.
But you know, ideally, under normal circumstances, forgetting about our practice, you realize that many times the people who are doing these innovations are these freelance guys, and they do it for fun. Yeah. Then along the way, something comes and says, wait a minute, this is my work. So there you are. Take us through.
Okay, maybe I'll start with that one because it's the one that's fresh in my mind. Then you help me repeat the first question so that I can be able to answer. But I'll start.
You can start with that, no problem.
Look, this is why we emphasize that it's important for you to be able to talk to a lawyer. And I think, honestly, it is true, it is us. And us, I'm not talking about individual lawyers, but I'm talking about the body of lawyers that have made it so that we have put a divide between ourselves and our clients or our potential clients.
Exactly.
We have looked at the law, like I said, from the perspective of applying it, but not from the perspective of explaining it. Ultimately, yes, that should be the mandate of government to be able to sensitize the public about the laws that come out. But as practitioners, we also can't help but do that. And that's why I was looking forward to sitting with you on this. So thank you so much for having a platform like this where we have discussions around how the law should work and what it means basically for the laws that we have, not just for the lawyer, but for the public as well that will be listening for this. Because once the public understands that don't only go to a lawyer when there is a problem, don't only go to a lawyer when you want something done, go to a lawyer for advice because you don't know what you'll have missed. And that's also why it's also beautiful to be able to specialize, because then the more that you work in a particular area, the easier it is for you to be able to see more things. We build our practice from experience. Most of the matters that you'll handle, you'll have handled a matter before, and then you remember, I can be able to apply this with this client. And that's what will be able to add value to them. So it is a myth that lawyers are expensive when it comes to these things, or maybe if we are, that's something that we need to change. Because the truth is, like you've said, these startups require us to be able to work with them from the perspective that eventually they will get that money, or we need to come up with better models to be able to work with them. Especially, I like the question looks at the innovator raising funding or money. You can put your legal fees in during that particular raise, so you defer them until that happens later. But to answer the question that you asked, I think first I may lose my train of thought. If you can just that second question, because that's the one I want to start with.
Section 8 says employer owns the copyrighted work created by an employee. In the course of employment. But most fintech MVPs are built by freelancers, and campus developers with no written contract. Walk us through a legal position of a founder who discovers during Series A due diligence that their code base was built by developers who never signed up an IP assignment?
I would say that that particular developer would be in trouble if those freelancers decided to come back and say that actually you're using my code or you're using my work. You see, the challenge, in many respects, the challenge is that these innovators or these companies that develop this software do not have agreements with their staff. And the challenge with that is that even if you have employed someone to be able to create a piece of work for you, if they're your direct employee, ultimately we would call that commissioned work. Even if you are an independent contractor, that work would still be commissioned. But the challenge is if you don't have a contract, it's difficult to have evidence to show that maybe I have been contracted to create this software. Once you come up with your own evidence to show that, one, I haven't been paid, or there's no evidence that I was told I'm creating for someone, me, I thought I was actually creating with this person, so we are co or joint authors, then that's where legal disputes arise. So I would say first and foremost, it's important to have a software development agreement if you have commissioned an outside party outside of your employee. If you are if you are a founder and you have a team that is supposed to create, have agreements with them. Not just employment agreements, but agreements that clearly speak to exactly what they are supposed to be doing. Otherwise, then it is easy for them to say that, no, maybe I created this system outside of my ordinary course of duties, and as such, I'm entitled to a percentage or share of it, or I own it, and you're actually infringing on it. I should be giving you a license rather than you owning it. So what I'm saying on that regard is have clear agreements that define or dictate exactly what rights the employer has and what rights the employee has in that regard. If you're a founder later and you find out that you have hired a freelancer to create a system and you didn't have any agreement, that is a very slippery slope, because if that person comes up later, they may have a case against you because you don't have any agreement confirming how they were engaged. But the law can still protect you, seeing as if you have ultimately, we can now infer the contents of an agreement, not just from an actual agreement, but from the circumstances around it. You have WhatsApp messages, you have emails. Is there any payment that has left for someone to be commissioned? Because the law already automatically assumes or affirms that if I tell you to create a system for me, then I have commissioned you to create that system, and as such, I'm the one who owns that system. But in the absence of that agreement or contract, again, there are many issues that can arise in that particular scenario. Outside of that, maybe what I can also be able to add is that if you are a freelancer and someone has contracted you to create a system also without an agreement, then, well, on your side, I guess you have more leeway, because like I've said, you can come up later and you say, no, this, I was actually asked to be a co-owner or author of the system, and I should be able to get more money. But like I said, the law would still protect the commissioner, because then would look at the evidence to confirm how much you were paid, what is the market rate for developing a system of that nature, have you transferred the source code. Ultimately, all of those things would go a long way in being able to confirm that. But speaking about the Copyright Amendment Act, we're also seeing that for any assignments, for any licenses, these now have to be in writing. And so that is a prerequisite for that particular assignment or license to be able to work. So the only way that someone who has created a system outside of your employer can be able to safely give it to the person who has commissioned it is in the ambit of an agreement. In the absence of that, it's unclear, or it is unclear whether there would be an actual assignment of those rights to the person who has actually been able to contract them. And I think that is something that the law has done. Even now, in answering, I am not clear whether if you commission someone automatically in the law before, we knew that once you commission someone automatically, that right belongs to the person who has commissioned. But with that requirement for these agreements to be in writing, have you actually, is it a valid commission? Is there a step that has been missed in that particular chain? So I would say that ultimately, if I am advising a client, have agreements in place that clearly define the rights of your employees if they're the ones who are developing it, or a freelancer, to determine exactly what they're creating, how they're creating it, and that in that particular software development agreement, there are clauses or provisions that make it so that they assign all the rights to you in any of the work that they have created.
Wow.
There was the first question is the one that I wanted
sure,
to...
I'll come back to that. Ken, you punch through the middle of the nerve. Many times our practice, our businesses in many of our countries, third world countries of our nature, are built on friendship. So we tend to overlook a number of these basic things. So I am glad that you point it out, because I am a friend to Diana, I am a friend to Louis, and wait a minute, we are friends anyway. So we come up with something, and I'm saying, guys, you guys are very good, at coding. Could you just help me out? And I want to do something like this. And there is no agreement, there is no nothing, and it becomes a big bang tomorrow. And you realize that not even only at our level, the issue of agreements has always been a problem. If you follow the issue, the story of Mark Zuckerberg and his colleague,
who developed
Facebook,
yeah.
So the other one went ahead and he did the patenting and so on. One was left in in the middle of the road. So I think you bring in a very, very key school of thought. Innovators, founders, let us formalize these processes. It does not cost you much to get to a lawyer and say, look, we want to formalize this relationship so that everybody knows what is in for him, what's not in for him. Because it helps solve future challenges. And that takes us to the context. You need the lawyers from the beginning. Let them be part of your friends. And a lawyer, you should have that personal friend. Don't run to a lawyer only when you are in now deep trouble. You are tearing yourselves apart. If you have these conversations from the beginning, and I'll tell you, and I'm sure, Ken, you do it. Two young men will come in, and you actually see they can't afford your rent. But you see they're having a good idea. Are you going to throw them out? No. When they are simply saying, we want to come up with something that binds us together. You'll do it sometimes for free, because you are seeing a team that will come back tomorrow when their innovation is a bang. So I would encourage the innovators and the founders. Let us create that agreement. And I think now let me pick up the next question, which is...
because the first one I hadn't answered.
That's what I'm taking you to.
I'll just answer it very, 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 very quickly.
So the next question, which came from one of our listeners, says, Section 6 of the Act says that ideas, concepts, procedures, and methods are not protected. That sounds like it covers literally everything valuable in a fintech company. So what does not cover literally everything, everything. So what exactly does copyright actually protect for a fintech founder? And is it worth anything practically?
So you need to understand that particular section provides context, being that an idea itself is not protected. The concept is similar to an idea. They're just using different words to be able to say the same thing. So an idea, a concept, the third one was what? It's idea, concept, and what?
An idea, concept, and works, ideally. Just a moment, hold up. So I don't want to divert the idea, concepts, procedures, and methods.
So all of those are the same. Well, a procedure and a method, I would say they don't have that tangible expression per se, or even if you do so, then you'd have a right in something else. So the short answer is that as a fintech owner or innovator, you would have copyright in the system itself. That one is not an idea because you have expressed it. So the source code. And as we said, for copyright, actually, you don't even have to focus on novelty. Once you have expressed the code, you actually have the code that does something tangible, then you have copyright in it. You can break that down further as well in your particular system. How elegant is your code? How easy is it to use? So you can also have copyright in the design, in the interface itself. How it has been designed, what button is here or here. So that design of the system. As I mentioned as well, you can also have copyright in the database itself if it is a financial system perhaps that aggregates data or is able to refine or sieve data in a meaningful way that the person who is using it on the other side is able to use it.
True.
So that you can also be able to, as a fintech owner, have a right in the database itself. I mentioned to you as well that outside of copyright, you can also be able to create a system that works or speaks to other systems, and maybe that can then be able to get that person a patent or get that person a utility model. So outside of copyright, you have all of these other rights as well that come as a result of you developing a system. But if you look at it from an idea, like I said, or a concept, that one, all of us can come up with ideas. So it is how someone expresses that idea that gives it that protection. So for a software system, it already has protection covered under the Act. So you just need to read that section just from that context of trying to explain to you what is not copyrightable, and an idea is not copyrightable, or just a mere way of being able to present information as well. That is also not something that will be able to get copyright. Again, that's why we stress it's important for you to go to a lawyer so that they can be able to break down for you whether something will be able to have, whether something will actually be protected or not.
Wow.
Yeah.
I am glad that my friend Louis Kizito is here. Louis, you're welcome. Louis is an advocate who is very, very passionate about these conversations and a very, very big contributor. And I think what you bring home is that an idea is already now by law. You have your idea, you have expressed it, it's copyrighted.
Yes.
Automatically. For you to move it to the next step, you want to have a utility model, then you must show novelty.
Yes.
Yeah. So the question, like it has been expressed, is that yes, they are what is automatically protected, like Ken is saying, but the moment you move beyond just an idea, expression, a creation, and then you are expressing novelty, then that's when you are now moving into things like utility model and so on and so forth. Thank you very much, Ken. I want to, without diluting your very, very good submissions, I want now to go to our next phase of questions as sent in. The amendment bill requires all copyright assignments to be in writing going forward. And is that a new standard or clarification of existing law? And practically, can a founder chew past informal arrangements with a retroactive written deed? Or is the IP ownership irretrievably compromised? I am looking at a situation. I had an arrangement with Louis, informal arrangement. And along the way, I'm realizing, wait a minute, this thing here is likely to bring in dollars. Can now, what the client is asking, can I retroactively now go back and say, wait a minute now, the past doings now, can we be able to reduce them in writing, plain? I'm sure that should be something you'll be able to handle with ease. And I want to merge those two questions because the other one is the Act protects electronic data banks. For a fintech that has built a proprietary data set of mobile money transaction patterns, credit histories, and circle payment records over 3 years, is that data set copyrightable under Ugandan law? And what is the test? What is the practical?
Yeah, 100% that is copyrightable. A database is really, for you to be able to have protection, it must be a database that just doesn't merely present information, but where, I like how you put the question that it analyzes those patterns and is able to produce something coherent. 100%, that is why the database right exists. And you can be able to have a right in that electronic database. And actually, we encourage innovators to be able to now look at data as an extension of intellectual property. My view is that data should be a separate intellectual property right, the ownership of data, because personal data has value. And we are seeing that in a database, even beyond that, it would be good to look at data protection per se, and perhaps extend it and create a separate right, which is like copyright, but in the actual data itself, so that even you, the user whose data is part of that database, if you identified, maybe you would also have something coming to you in that regard. But ultimately, if you are, but also some of the considerations of course also go in the realm of data protection, that do you have anonymized data sets? If you have personal identifiers within that data, you can't own IP in another person's name, or another person's national ID number, for example, if that's what you're doing. But beyond that as well, you may also fall into problems when it comes to data protection and that aspect of consent. So if those data sets are anonymized, at least to an extent that you cannot be able to pick or identify a natural person, 100%, you're able to own that right, and you're able to commercialize it as well. And many people have actually commercialized those databases that way. I think the first question was regarding. Sorry, you ask the questions and then I focus on the.
I think maybe before we go back that question, I just want to amplify key areas. So I just want to amplify a few things for the benefit of our listeners, Ken.
Okay.
Many of our innovators have not actually appreciated that in the coming years, what is going to be more marketable
is data.
Is data.
Yeah.
Data is the new gold mine.
Yeah.
And that's why the West realized this many years ago.
Yeah. And
I've always replayed this conversation. And the conversation I've always played, I've always said that a story is told that they developed Android and gave it out for free. All you needed was to consent. And in consent, you are giving out your data. And you have all these social apps, Facebook, X, which we are using now. And we don't pay a dime to use them. The question is, how do these guys make the money? Or they are too generous that they love us so much, says, don't mind. We will develop an app for you, you use it, enjoy it. No, that's why they're asking for consent.
Yeah.
So you really amplify a very key factor that, yes, this data is copyrightable. And you highlight key things which are really very passionate to me. How is data how are you able to make data good data? It's not just data. Yeah. If you're going to have medical records of patients and you are having their names and their village and every detail of that patient, because by virtue of your area or your innovation, you got access to this data, then that data is not going to be good data if you have not anonymized. Because even when you have the consent, like you're saying, you can't have my data in my names and call it your data. Yeah. So I think the take home, one for the innovators and for the lawyers, is that it is key that when it comes to sensitive data of that nature, you anonymize these characters. Yeah. Number two, you also bring in a very, very key thing. Is it copyrightable? Can I have a right by say that I own this data? And the answer is yes. What I wanted to amplify in that area is that I think it is time now that we started trading data as oil. And for us to do that, we must be advised on how we should collect this data. Do you have a license to collect the data? Are you a data collector? Or you are just collecting data because people do not know that you are collecting it, and they don't know that you are going to use it or sell it or use it in areas that you have not given consent. So I think you highlight a very key thing: consent, consent, consent. That's one. Number two, collecting data ethically.
Yeah.
Because the National Data Protection Office gives guidelines on how you should collect data. Yeah. So and these are conversations which Agri should be able to appreciate by interacting with lawyers.
Yes.
My friend Agri collects data every day. He takes all these beautiful photographs and so on, and he remains with copies in his in his database. Yeah. And tomorrow, when I'm looking for a flyer to advertise my mango juice, he will be able to give me a flyer. But the question is, do you have consent? You have this data. Yes, you have this data. Do you have consent? So I think these are basic things which you drive down to our ordinary people. And I really want to thank you very, very much. And now I would want to remind you your question. You started with the juice part. So let me take you back. It says that
assignment.
Yeah,
writing.
Yeah.
No, I've actually remembered it. So the question is around assignment in writing.
Yes.
So you see, ultimately, even outside of intellectual property law, if you remember your contract law, it's that for any contracts above a certain amount, I think it's 500,000, or yes, I think it's 500,000. They should be in writing.
Yeah.
But number two, that issue question of ownership only comes up at that point when there's a dispute. I'm looking at it from a practical perspective.
Yeah.
So what the law says is that if you're for you to have a valid assignment, it must be in writing.
Yeah.
That doesn't mean that when you assign, at the point when you assign, without you having a contract at that point, it is illegal, or that when you then have it, when you do it later on, it really will not matter.
Yeah.
What will matter is that at the point when you, if someone wants to rely on that assignment to say that this is the day that I actually owned this particular intellectual property right or copyright, that you did so under cover of an agreement.
True.
So the practical answer is that yes, it is okay. Maybe if the registry wants to be complicated by the time you go there, but the practical answer is it is okay.
Yeah.
You can be able to still prepare an agreement later. But ultimately as well, that agreement has to be registered, or now for that assignment to be valid, it has to be registered. That is something that is new. That for someone to own that IP right, that copyright, once they've received it, the only way that the law can confirm that it is theirs is if you've notified the regulator that I assigned this right on this day, I was given this amount of money, or I paid this amount of money, and then they give you a document to confirm that actually that assignment is valid.
Wow. So there you are. You can always do your agreement even after you have made some movements. Ken, you come from a perspective of a lecturer, and I'm glad you are actually teaching this specialized area, and clearly we cannot be able to learn the whole intellectual property which you teach for a full semester in 1 hour. But I can confess you are doing an amazing job, and I'm sure many of our colleagues who are here are saying, yes, I think I never did the IP. I think I missed out. So it is 20 minutes past the hour of 8. Our time is fast spent. So I am going to ask you to give us your view on the amendment bill. And I'm not going to ask you particular questions.
Okay.
We just want you to give us what your take is.
Okay.
You have read it, and there are issues from a number of us. I will give you a latitude so that it's able to solve our time pace. And I will also want you, after that, we'll be looking at the legislatory IP intersection with your overview. And thereafter, I will open up a window for some questions A number of them, I've been picking them from our Twitter handles as they send them. So please, over to you. What are your thoughts on the amendment bill?
Well, of course, whenever you have an amendment that answers some practical questions, it's always good for the industries that benefit from that. So overall, for me personally, as a practitioner, especially one who has represented artists or who represents artists, musicians in particular, they are lucky to have these amendments. It's one of the few times that government has come in to actually set a standard or to regulate something outside of banking. It's only in banking where they will tell commercial banks don't lend beyond this or don't do this, but even then they give them latitude. They tell them maybe this is the central bank rate, and so you have a particular space within which to give interest within that particular guidance. But here they're saying that if you are a telco and you're going to use a caller back tune, then this percentage goes to you, this percentage goes to, it's rare. And you can clearly see that was a political move.
Yeah.
So for the artists, I think they are the ones who have benefited a lot. For the lawyers as well, these provisions we're talking about, the contracts have to be in writing, assignments have to be registered. If there's now a threshold for how long someone can be able to own a right, some rights have been extended. There is more work for lawyers. And so that is a good thing if you're looking at it from that perspective. And it has also become more relevant for artists and for creatives to be able to go to lawyers to interpret for them what the law says. So I would say in that regard, yes. But overall, I would say that this law, and this is such a shame that whenever we're looking at copyright law, we only mostly think about music. But what about other sectors like film? What about other sectors like the fashion industry? What about other sectors like the digital artists? So for all of those, there are perhaps certain aspects that could have been defined, but like we said, ultimately, maybe that is a question of lobbying or for the various associations to be able to speak to government in a way that the musicians did, and then maybe those amendments can be able to work. It would also have been nice, I join issue with my colleagues who are saying that why didn't we define artificial intelligence?
Yeah.
Why didn't we look at AI-generated work? Make it so that answer that question in Uganda, at least if someone uses AI to create work, who owns that work? I think worldwide, the accepted position is that only human beings should be able to own work. I think that should also be a distinction that is made here. So it would have been good to look at AI-generated content from that regard, but also to look at people who use AI to be able to recreate, other people's likeness or etc. Of course, that is now another realm. We're looking at image rights, which do not necessarily fall under copyright. But I would say that some of those principles still apply, in regards, again, to the use of such technologies. We have a provision that looks at the circumvention of technology, but that's from the perspective of infringement, but not from the perspective of creation.
Yeah.
So there are gaps in that regard, but it is very difficult to say that you can have a law that really covers everything.
True.
But it is true as well that once you have a law, especially that is regulating a sector, it should be able at least to cover 80 or 90%. And I think ultimately the fundamentals of the law, for me, I still believe are still fit for purpose, being that you can have copyright, what things can have copyright, what things cannot, what happens if there is infringement. But so from the practical perspective, that's where maybe it would have been good to talk, to see other amendments that address many of these things. Like, for example, this issue of Anton Pillar's order being expiatory or not, that is a question that we have been grappling with for such a long time, being as there were directives from the judiciary that all applications should be inter partes, but how do you have an Anton Pillar's application inter partes? Yeah. So, things like that as well would have been nice to clarify when you're looking at infringement in that regard. Also things to do like with valuation of intellectual property, since now we're looking at things like using intellectual property as assets or collateral. So some of those, I feel that disconnect is that the law is still prescriptive, being that it provides for the right and provides what happens if you fail to do that, but it still lacks that latitude to speak to the actual issues that the creatives have in regards to the law working for them in a practical sense, apart from the musicians who are benefiting or will benefit from those particular distinctions, where now they could just go to a callback tune and the law has already given them bargaining power in that regard. Also, the collective societies as well have been given a lot more power and latitude. That's a much wider discussion as to whether we should have only one collective society per right or per bundle of rights. I think that should be a sector for me that needs to be liberalized. I think there are a number of companies that would do a very good job in helping artists to collect their royalties. But maybe that is a conversational discussion for another day. Yeah.
You know, can you make this whole conversation so sumptuous that it reminds me of the conversation I had this morning. One of my colleagues here, David Baluku, is a DJ. Now, David asked me a question, says, you know, Tony, I can sit on my computer now and I recreate Juliana's song using my computer, using artificial intelligence. And the song comes out. It is Juliana's voice, but it's not created by Juliana. It is created by AI. So the question is, where does your amendment protect Juliana, and how will they catch me? I will have my song, and can I be able to rip from my song? Because I created it using my AI and I have uploaded it. And YouTubers are busy, you know, subscribing. And maybe not long after I will start earning from that song. Can Juliana sue me? And when she sues me, does she have a cause of action?
Tony, that is why I was saying that the law is not practical in nature when it comes to things like that. Because you see, in that particular scenario, unless you have recreated Juliana's song that already exists, your cause of action in that particular regard would not be in copyright infringement. Because with copyright infringement, like you know, you can only infringe something that is copyrightable.
Exactly.
The voice or likeness, as at the moment, is not copyrightable. That would fall, like I've said, in the realm of image rights, which we still borrow from common law and from precedent. We now have good cases that have prescribed that right and have made it so that so Juliana can sue for image rights infringement, but not for copyright infringement if it is another song, and it's not a song that she has created. So it is. That's why I feel definitely that we should have had a lot more discussion around the use of AI, even in the copyright sense, especially for things like that. At least, you know, it wouldn't have. It would have done more good to be able to prescribe and say, for example, that someone should not be able to use AI to recreate, you know, someone's likeness or this. If they do, they create an offense. Something like that, even within that particular law of copyright, would protect the creatives themselves. Or, of course, we already know that for the artist, it is easier if someone uses AI to recreate your digital art or creates a digital version of your art. That would still be infringement. It wouldn't be, well, technically it would be a derivative work, but like we know, for it to subsist as a derivative work, it's one question for you to have copyright and for that copyright to subsist. So as we know, copyright is inherent. So once you create the digital version of art, they already have their copyright. But can that copyright subsist? The answer is no, once you have copied someone's physical art piece without consent. But still, without the law prescribing it clearly, it is a problem, because someone can say, I was inspired by the piece. And then when you go, you say, no, my piece may look the same, but
different.
I was just inspired and I created it through different means. So it would be interesting to adjudicate or to hear rulings that come out of a case like that.
I know.
Like in that scenario, the answer is not straightforward, that there is copyright infringement. Because like I've said, I've used my digital tools, I've recreated someone's art piece, I have been inspired, and there's no problem with you being inspired by something. So the question is there direct copying? With copyright, it is direct copying. So I do think that overall, these amendments perhaps should apply more practically to these industries, to scenarios like those. Like in that scenario, definitely, if a print artist has their work that has been replicated in a digital environment, automatically, for me, that should be infringement.
True.
It should, that person has actually derived that work from that, and there should be consent in that particular regard. But it leaves room for interpretation or for disputes without being able to clearly define work that is created in a digital environment, but that is based on or that is recreated from work that is physical. Yeah.
Wow. Thank you very much, Ken. Our time is fast spent. Members, today we have a very, very exciting conversation, and you will lend us some more 10 minutes. I promise we won't go beyond that. Ken, the theme on regulatory IP intersection, I would want to read these questions verbatim.
Okay.
Maybe to guide your conversation. Okay. These are questions we got from a number of our listeners. One is, NITA-U requires detailed system documentation as part of software certification process for BOU licensing. That documentation describes how your product works. Is what you submit to NITA-U protected as confidential? Or are you effectively putting your technical trade secrets into a government file that could theoretically be accessed under the Access Information Act? Number two, Bank of Uganda has audit rights over licensed payment service providers under NPS Act. If BOU auditors come in and ask a Fintech to explain how its credit scoring algorithm works, can the company refuse on grounds that the algorithm is a trade secret? What is the legal position? Those ones I had to read them verbatim because, yeah.
It's a difficult balance to strike between regulatory compliance and ownership or authorship. In that regard, honestly, I do agree. First of all, in being able to unpack that, if you're applying for a license, I assume you're applying for a National Payment Systems license from Bank of Uganda. NITA will ask for a separate type of license, which is the ICT certification. But they do also ask for information about the system and how it works. And in essence, that should be confidential. It's not public information. But that's why it's also important for you to be able to apply for copyright or for whatever intellectual property right even before you make these submissions. In essence, then you will be covered 100% without having to go through any semantics. But that information should be privileged information for purposes of your application. It's not public information that someone should go and search and be able to get it. But of course, once you submit it, being the nature of our regulators, you're not sure that another person won't be able to get it. So I'd say that striking that balance, that is a problem that the regulators should be alive to, and perhaps give more confidence to the users that when you submit information for license, it's not going to be misused a certain way. Bank of Uganda is a lot more intrusive. If you're applying for an NPS license, you have to show exactly how your system works. Again, the answer to that is that apply for a right before. Copyright may be inherent, but if you submit it, another person gets access to it without you having to go to the registry. If that person goes to the registry before you, the law is going to look at that person as the person who actually owns that particular right. So I would say that, apply before, get IP protection before you are able to get regulatory approval. But information that you submit to a regulator is privileged and should not be shared in any way. If you find that it has been shared and someone has gotten access to it as a result of that, you would have a cause of action. You come to Tony or myself. We will definitely talk to Bank of Uganda or talk to NITA-U on your behalf in that regard. Yeah.
Wow. Thank you very much. I think there you are. You get IP protection, like Ken is saying, before submitting these things, and make these lawyers part of your process. Let us not be co-wives. Let us be partners in this trade. Yeah, it is very important. I want to just wind up this other last bit of it. I promised to just give you a latitude, but unfortunately, some of these questions require you to have them verbatim. Uganda's Personal Data Protection Act gives data subjects rights over automated decisions that affect them. As mobile lending algorithms become more common in Uganda, will a regulatory requirement to explain AI-driven credit decisions start to erode trade secret protection for fintech models? Has this tension arrived in Uganda yet, or is it coming? Number two, the Bank of Uganda regulated sandbox specifically designed for testing innovative financial products without a license. But participating in a sandbox requires disclosing your system to be oil. If your fintech participates in a sandbox and your innovation is later copied by the larger player, how do you protect yourself? What should be in your sandbox participation agreement? I know who sent this question, and he's trying to dodge. I wish I'd read it before. He's trying to dodge fees, but anyway, I have read it. There you are. Please.
Indeed, man. These questions are. These guys, yeah. People are checking our tool of trade. This is work that I pay for, but I guess we are performing a public service. Okay, so I'll start with the first one. It's a good question because actually I took lead on an assignment with the digital lending sector.
Yeah.
UNCDF, I was contracted by UNCDF to advise the digital lending sector on digital lending and with a mind for the digital lending sector to self-regulate. And so I conducted research and there's a report that I published. The outcome is that we developed codes of conduct that these digital lenders could be able to use. But that question of automated decision making is something we actually discussed with the PDPO. Their position is that the current data protection law is adequate in the sense that once you have data processed by automated means, then you should have an additional layer of consent. So it covered artificial intelligence in that regard. Yeah. But ultimately, I feel that still, since we're looking at AI generally, we should still have specific part of my recommendations was that we should have specific regulations that look at AI processed by automated means. As to whether that stifles innovation, I can't see how. Because here you're looking at it from the data protection perspective, being that if you're going to explain to the data protection authority, it's that if any part of your system has a non-human that is collecting data, then you're informing the registry and also showing them exactly how you are handling that aspect of consent. Do the customers know that an AI or whatever application is going to collect this is going to collect this data or is going to process data? If they do they know who you're going to share or where that data is going to be shared? So yes, I can't see how that would cause any problems from the innovator's perspective. I would think that comply with the law. It's a data protection question, and I think it is good to assure the data subjects that their data, if it's processed by a machine, it's not going to show up in another with another person or another company seeing that's what you are talking about, these social media platforms. That's how they make their money. So that is it in that regard. The second question was on what? On
sandbox with the Bank of Uganda.
So the way that a sandbox works is that it allows the live testing of products with the oversight of a regulator, a big boss who is there sitting and making sure that you do whatever you want. And like I've said, any information that you submit to Bank of Uganda is privileged. I don't think if I want to see how the mobile money net system or network for MTN works, I can go to Bank of Uganda and they can give it to me. No, the law does not work like that. It is that if I'm submitting an application, I'm submitting an application individually, and Bank of Uganda considers it, and the team that receives these applications should be able to process my application in a confidential manner, and no one should be able to know about it. So even in a sandbox, the information that is released is that there's a product or there is a system that is on the market that may not necessarily be covered by the law. And so the regulator is trying to figure out exactly what framework to use in that regard. So it is more from the perspective of licensing rather than from the perspective of it's more from the perspective of licensing to use rather than maybe ownership, or that again, that if you submit that information, the public will have access to it. No, no. It's that they'll have access perhaps to how the process, maybe if what you're trying to get is a right of is a patent or a utility model of a process. Maybe if I'm thinking really outside of the box, but again, I go back to, before you go to the regulator, why don't you protect? So that you're going to the regulator to license you to use your product to the public, but not to give you permission to use it. Ultimately, you can create, and then you register the IP right, copyright, patent, utility model, whatever it is, then you go and apply for license so that the public can be able to use that. That prevents really any issues that will arise as a result of you live testing your product. But also, from a patent perspective, you also need to note that if you live test your product to the public in a regulatory sandbox, it's possible that you can lose novelty. As you know, the law gives you 1 year for you to be able to apply for a patent if you disclose it to the public. So do not disclose anything to the public. Regulator may not be categorized as public. Like I've said, the expectation of the law is that once you submit to Bank of Uganda, once you submit to NITAO, your application is handled confidentially and is not necessarily looked at as public in the context of IP law. But it might be if the regulator is going to announce that we have this product that utilizes this service or this service. If someone is skilled in the art, it could be possible that they could be able to utilize that information to create a system. All they needed was just for someone.
Idea.
So I would still say apply for registration before. And the good thing with patent or utility model is that what you get, that filing date is enough. You don't need to wait for the entire process for the patent to actually show up. What you need is the filing date, and that is sufficient enough to be able to stop anyone from infringing on your product or from suing another person if they release your product. But that would be under the law of confidence. I would say your cause of action would be under the law of confidence, because that is proprietary information submitted to a regulator for purposes of licensing. And if they release that information or disclose how your system works, you would have a very big cause of action against them in that regard. Yeah.
Wow. Ken ideally has had one gospel, and the gospel is protect yourself before entering the game. Whether you're going into a sandbox, you are with the regulator. Yes, have the confidence with the regulator, because you have no shortcut. You need the regulator, but have your IP protection early in time. And I think you also portray a very simple message, a practical message. That there is this impression which is created that the process is so complicated. I mean, look for Ken, look for a lawyer who understands intellectual property. We are all trained differently. We are trained the same way, but we pick interest in different things. If you come to me and I'm a lawyer for animal rights, you want me to be advising you on intellectual property, then you're in the wrong area. So I think those are some things which also, as innovators, need to pay attention to. We are now moving into an area where specialization is key. So look for a firm that has specialized in a particular area. It will be for good benefit. Some of this information, you get it with a lot of ease. And the bottom line, I think what Ken is saying, protect yourself. Don't run away from the regulators, because you can't do without them. Until you have a cause of action in case they breach, which they rarely do if they do anyway. So thank you very much, Ken. And this brings us to the last phase of our questions, and there are going to be very few. Then I will ask our listeners to chop in. Our last two questions. Number one, if you were advising a Ugandan fintech founder who has just closed their seed round and has a budget of 20 million, that's around 5,500 USDs, for IP protection over the next 12 months, how do you tell them to spend it, and what are the priority actions in order?
That is an innovator who has developed a software application?
A Fintech payment system or something like that.
Oh, that is a lot of money. Definitely that is a lot of money.
We're talking about $5,500.
It is, yeah, it is, because the actual cost for registration of copyright is cheap. 20K to 25K to apply, and then 50K or whatever. It's less than 100,000 shillings for you to be able to register copyright in that regard. The patent will be a lot more expensive, because then you have aspects of being able to inspect it. You need someone who is skilled in the art to be able to look at it and advise you on how the claim should be drafted or drawn. So, but really, all of those now, once you go to a lawyer that has handled these applications, it should be easy to be able to break down that amount and get someone to be able to have the claim done for you, and then also for you to be able to apply for the patent. I would say that as an innovator, your money, that money should be allocated, one, from, like I said, from the outset, being that any agreements that need to be prepared along the value chain, the questions you had earlier about you have a freelancer or have a software development agreement, maybe that one can take up some of that money. Outside of that as well, the advice is, where do you want your application to work? Maybe that money would be, you'd need more money if you're going to designate many countries. If you're going to apply, let's say, for a patent or for a utility model, applied through a RIPO or WAPI. If you're going to designate a number of countries, then maybe you may need a little bit more money. But also the application fees for a patent are more than for copyright. So maybe you may need more than that. But I would say start with, as an innovator, know what market you want to operate in. And then I would advise you not just to not to register only in Uganda, but through a RIPO, and you designate the countries where you feel your system or network should work. If it's only Uganda, then that's okay. You can go through our URSB, you patent, you copyright, you get a utility model, whatever it is for your system. You use it or utilize it there, but you'd have to go through that same process if you're going to use your system outside of Uganda. So I'd say agreement and then the actual registration. But I want the listeners or viewers to know that it's not expensive to be able to register their copyright. The patent is the one we're still fighting, because, like I've said, it takes a long time, and also in terms of time, you have to be able to measure, but maybe that will change as well over time.
Wow.
Yeah.
Now, you guys, you realize why I asked, who is Ken? Because Ken is here spilling all our secrets. So those who sign up with Diamond Advocates, take everything Ken has told you. But the money, I'm not sure. That I'm not really very sure. Because, but bottom line, these processes are not complicated per se, but professional fees also vary, because the lawyer is not only helping you to register your patent, to do your protection alone, but is equally going an extra hand, helping you draft some of these agreements, advising you. And that's what lawyers are going to charge you for.
Actually, I'd want to add that for me, where I would focus on billing would be on the commercialization of the IP.
Exactly.
That if an innovator comes to me with a particular system, I won't charge you a lot to be able to register, but I'll know that you need to have agreements with your clients. You need to commercialize basically what you have created.
True.
And that's where a lot more technical work goes in, because then if you can't, like you said, you can't go to someone who's not specialized to understand the nuances of a software development agreement.
Exactly.
You need someone who understands exactly how data protection works, so that you can be able to incorporate data protection by design. So all of these are concepts that can be best understood by an advocate, and of course, ultimately as well, if you're billing, the more experience that you have when it comes to time now on the advisory side. Yeah, like you said, the fees will vary.
Thank you very much, Ken. The lawyers I don't want you to kill me, saying now you brought Ken to just throw us under the bus. 2 last questions. One, what is that single most common IP mistake you see in Ugandan fintech founders make? The one that is completely avoidable but causes the most damage when it surfaces.
That's not signing agreements, not defining the rights of all the parties involved in that process at the point when they're developing.
Perfect. Next, to that young lawyer, this is normally my last parting question before I open the floor, who has been seeing Ken from the time he joined law school, says, you know what, when I grow up, I just want to be like Ken. I want to practice intellectual property. What are those do's from the time go for somebody to come out as an outstanding attorney in the practice of intellectual property?
Know your stuff. I would think that because if you choose to go into a specialized area of law, you're not only competing with people that are in your market. You are now added to the global audience. You know, you're now tasked with making sure that law firms outside of Uganda are not undermining work from Ugandan lawyers because of the quality of the work. So I would say that focus on, pay attention to detail, have that technical capability, read, understand, don't be too quick to outprice clients so that they run away from the money that you're billing. Encourage them to be able to come in so that we are able to build the volume of work, but focus on that technical aspect as well. You know, be able to advise a client because you have either handled a matter or you've read about a matter or you've consulted with a colleague. That is the third thing, consult. It's very difficult to say that I will know everything or I'll have looked at every single angle, but having a call to a colleague and say, look, how would you have handled this or this? Even if it's just bouncing ideas. I feel that's something we don't do a lot, and I think it would help our clients from that perspective, because like I've said, if we are going to create work, it has to be a collective effort of the lawyers or practitioners in that field to know that the reasons why a client is going to a lawyer is because they know that there's that quality aspect, or they know that ultimately there are people in that field or area of law that would be able to handle that. Maybe lastly is thinking outside the box. I would think that as a lawyer, like I've said, you need to reframe or reorganize your mind to not only think of yourself as a problem solver. You need to think of yourself as a facilitator for your client. That if they come to you, they may come to you with just one concern, I want an agreement. But ultimately, you should think of yourself as a business, or even if you're working within a law firm as well, you're also growing your practice, you want that person to keep coming back to you. So how do they do that? Is by you adding value to them. This agreement, who is going to receive it? What aspects should I be able to look at? That's a technical etc. But how can I also assist you to be able to market your product or to get your product where you want it to be able to go? I think if we think about it that way, it would be, we add more value to our clients. So for me, when I am interacting with clients, that's what pushed me into policy. I recognize that we shall talk about IP, or talk about the practical applications of the law, but if you are not aligned on the law that these clients operate, then it becomes difficult for them to operate, and ultimately you don't have any clients. So I would say that if you want to specialize in this area, read, put in the time, make sure that you actually also consult, but beyond that, understand your client's issue, not from the perspective that it is an issue, but as a lawyer, how can I be able to receive my client and they get value from me? It's not just that they're paying me, but how am I also going to add value to what they're doing? Trust me, that way you have clients for life. But beyond that as well, they will recommend you to another person, then to another person. Something good is always recommended.
Wow.
Yeah.
You bring in a very, very missing link. To the lawyer out there, the young lawyer, who are many of our listeners normally, this question is normally dedicated to them. And like you have said, know your craft. It's very, very disturbing when you meet a client and he seems to understand more than you understand the concept.
And now it is easy with ChatGPT and things.
So take time to read, And the mind is like a computer. The more subject reading, the better it becomes. I know there is the dopamine effect now because of these gadgets, but I subscribe to your school of thought. Know your craft, read, prepare, and prepare. Never forget.
Actually, Tony, in speaking that, I just wanted to add one last thing there.
Yeah, sure.
Because of the use of AI, it's very easy as well as a young lawyer to, because maybe you are receiving many instructions, or so you want to take that shortcut, but you're risking you not being able to learn.
Yeah.
The reason why I can sit here with you and answer this wide range of questions, even without reading, is because I have practiced and they are habitual in my mind.
Yeah.
But it's very easy, I've noticed, if you're using AI to be able to prepare opinions or to answer questions, you then end up relying on these technologies, but you're not learning or you're not growing.
Exactly.
And then your answers are also becoming generic, but you also cannot put that human element, like I've said, of being able to approach a problem or approach an instruction from a wider perspective of where else can I be able to plug in, where can I be able to add more value. I can promise you that for many clients, they've come to me with one thing and I've left with like 5 or 6. Now, AI cannot do that. But the only way they've been able to do that is in a meeting when we're talking. And like I've said, I remember something I've worked on, or I remember something I have done, and it's easy for me then to be able to say, oh no, but you think about this, but why don't you do this or this? So I would say that as you're using these AI tools, use them to make your work easier, but do not rely on them to do your work. That, I feel, is a message that I hope the young lawyers take into their practice. It's going to change your brain, and you'll notice in 5-10 years now, when you're in Tony's seat, you cannot review work because you have to have your computer or your phone to be able to do that, or you're not seeing a matter from a broader, wider perspective. You're just looking at it now theoretically, like how we were taught in law school. Practice is very, 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 very different. And those that succeed, those that set their mark apart, are lawyers that are not thinking just, let me answer this way, but how can I be able to approach a question or problem, like I said, from a wider scope of perspective that adds value to the client and also looks at the bigger picture.
Wow. Ladies and gentlemen, we are with Ken Muhanji, partner with KTA, and your host, Galandi Tone Kire, Diamond Advocates. And we have been discussing a topic, imitate or innovate, striking the right IP balance and protection for Fintech innovations. This is an emerging area of practice. It is a gray area. It is a virgin area. We encourage practitioners to join it, but also we encourage innovators to make use of legal practitioners and the right legal practitioners. Ken has said his door is open. Diamond Advocates, the door is open. Will help you grow. I don't want to close this without giving a chance to our listeners. My friend Louis Kizito, your hand is up. Please open your mic and give your comment or ask your question. Thank you.
All right. Thank you for hosting, Ken, for quite a very experienced and knowledgeable person who reads voraciously. But for me, just my concerns, and before I proceed to the general comments. Innovators, and I think this goes to all of us legal practitioners. Whenever we're talking to these innovators that have these like GitHub licenses, and you talk about IPs, like for them, you're telling them things that don't matter. Because for them, they can just write a whole code on GitHub, and they know how to access their things. Now, once you tell them, guys, can we regularize this in a certain way? There are laws doing this and this. Don't want to listen. So I don't know if Ken has encountered that, but I would like to hear his comment about that, because it's a very common thing. And then recently we were doing a regulatory impact assessment for virtual assets, crypto assets, that is. And I had a very huge debate with the head of payments, Kunemans, who heads the payment systems department in BOU. One of the things he's trying to do is, the law says that you can actually apply to the sandbox without a license. That's the law. Unfortunately, the director of payments is telling people in there that no business entering the sandbox. And when we complain, we had a back and forth with the legal department of Bank of Uganda, the legal department went back to the director of payments and told him, guy, please, you are wrong. The law says that anyone without a license can enter into a sandbox. So I think my experience using that sandbox, it's not a good one. I think there are only 2 companies I know that have been through the sandbox, but I stand to be corrected. Maybe Ken knows some extra information. Then one last thing. This is my second last concern. I don't know if you guys know what these non-fungible tokens are all about lately. You know, these blockchain-generated DLT issued instruments, non-fungible tokens. They are blockchain-enabled instruments. They're different from cryptocurrencies. But they leverage a lot of reference material that is IP protected, heavily protected by IP. Lately, we had an issue with OpenSea. OpenSea is an international NFT marketplace. And it's like if you are actually trying to do an NFT on issues coming from Uganda, it is actually much harder for you because now it's like they're doubting our copyright ethos, our copyright competence. So it takes you much longer and you have to do much more. If you're generating sort of a cartoon that is a Ugandan kind of cultural thing, they might not even want to know what the law says, but they will want to take you through all sorts of due diligence that the Americans may not do. So I don't know, maybe Ken, you might have something like that. And lastly, okay, for me this is now a concern, and I think as practitioners in this space, this is a general concern we are getting from the market. Guys, you know a company called Cheaper Cash, and I'm sure, I think Ken interacted with Cheaper Cash along the way. You might even have to them get a license here and there, I don't know. But a company like Cheaper Cash has about 3 licenses. When you go to Old Mutual is not a startup, it's a very mature company, but it's going into like 5 licenses in the financial sector. They have a license for asset management, fund manager. They have that's CMA. They have a license for retirement benefits, that is UBRA. They have a license for, they're about 4 or 5. Oh, insurance. So for me, from an innovator's point of view, and since we are in the business of putting together documentation to process licenses, some of these documents have a lot of proprietary IP work. Taking it to 5, sometimes even the same regulators whose code of regulation, some of them even have a code of how to regulate of their own regulatory behavior. Okay? I've been asking for that code from CMA, from IRA, and failed to get it. And I've been calling upon them to have their own code. Now, this is my point. I think Ken, Tony, and all other practitioners on this space, and I think Ken, has a bit more weight on these issues because he has been in this business longer than most of us. I've been shouting my horse off to have something called a Twin Peaks model of financial regulation. You look at it this way. Before the financial crisis, even in Netherlands, they had what we had here. Even in South Africa, they had what we had here. You have a CMA, you have a BOU. Okay, BOU of course can't go wrong. That one has to stay there. But they have an insurance authority. Now we even have 2 sandboxes. There's the sandbox for CMA, which thanks to some of our efforts, it's now there. But now, what I'm saying is we have very many licensing entities, which ordinarily can be under one rule. For instance, you create some sort of financial sector authority. Yeah? Where if a CMA wants to do what it has to do, I'm sorry, I need to be talking against some people's jobs, but for the best. CMA can be a small department, because when the UK Financial Conduct Authority does it say, they have the Insurance Act, it continues to be there, but it operates under a wider banner of the Financial Conduct Authority, like they use the South African Sector Conduct Authority, where the CMA regulates the conduct of the securities. Maybe if I want to do a robo-advisory service as a startup, because the startup trying to do robo-advisory, we can also have a lot of IP issues in it. So you end up having 6 licenses, and yet of late, fintechs are actually blurring the line between banking, insurance, securities, asset management, even advisory services nowadays are robo-advisory services where someone creates an algorithm which knows all the trading patterns and can advise clients on how to take positions in markets. So what I'm saying is, and this is my plea to Ken and Tony, is that the licensing is too much, and yet we can rationalize the financial sector. Oh, I forgot one other thing. There's also we also had the Uganda Microfinance Authority, which was pushed under the Ministry of Finance, which is supposed to be put under a larger financial conduct authority. Because there's no business, there's no reason why you're putting a money lending regulator, you're mainstreaming it alone, excluding all the other market regulators, CMA. So I'm thinking that the Microfinance Authority, CMA, Insurance Authority, UBRA, they can all, I'll take an example, and I'm really concluding with this. UBRA and CMA literally are doing the same thing. If I'm a fintech and I have a robo advisory service, I think we're working on an application of sorts. So they ditched Uganda and they went to Kenya. But if I'm a robo advisory service, I will actually be told, I will tell the client to get 2 licenses. And yet these guys are doing literally the same thing. I'll tell you, first go to CMA for asset management. But in the event you want to manage any assets in terms for retirement benefit schemes, you might need another UBRA license. So you have 2 licenses. And then at the end of the day, you also have to go back to bank of Ghana to get a payments license for another product offering. And at the end of the day, you also want to go into something. So the licensing, that's actually a double license. So my plea is for fintech space to grow. We should go and rise above copying and pasting everything we're getting from Kenya and think on our feet, because we cannot allow innovators to be bogged down by double licenses. Some of these licenses are not even they're necessary, but they can be streamlined. So that if I am having a financial conduct authority in Uganda license, and I'm offering a product on payments, on a payment instrument, on or if I'm going to do something else, I have no objection from maybe a CMA, which is within a larger firm, I can make it, but within one entity. Makes more sense for innovators. And then I think we should also look at an international financial center, which is different from a free zones authority, because free zones now is for it's more of an industrial for export, 80%. But a financial, but look at our neighbors. Kenya has a Nairobi International Financial Center. Even Kigali now has one. Even Congo actually has one. So I'm thinking we should also think in this direction, so that we get all the financiers who want to come in Uganda here, so that they have all the benefits that come with having an international financial center. And I think Nakawa Business Park can be a very good one. That's where I see Ghana Citizens Exchange, all mutuals, that's where I see most of these financial around groups there. So for me, this is my greater plea, and I think this should be a collaboration. Before regulatory harmonization in the financial sector is too much. It's costing us businesses. So thank you very much, Ken, for really sharing your heart out. And I hope we do more correspondences. These discussions are very enlightening. Thank you very much.
Thank you very much, Louis. Over to you, Ken. The licensing is too much. Yeah? CMA, UBRA, IRA, you're running everywhere. If you're a Fintech, you're running to National NITAU, National Data Protection Office. If you are dealing with money, you need you are running to Bank of Uganda.
Yeah.
So, what's your take, please, from the comments of Louis?
No, Louis, I will start really by saying 100% I agree with you. It is a big issue that we have. I saw a clip of our neighbors in Rwanda where they have like this auditorium-like setting where the president calls all his ministers, and then you have the private sector coming in to be able to talk about these bottlenecks.
Yeah.
I think we need something like that, because the challenge is there is definitely a disconnect when it comes to the creation of, and that's what I'm saying, our laws are more prescriptive. They provide for licenses, or if someone doesn't do something, but they're not alive to the actual reality on the ground.
Yeah. And
that's when you have duplication of these things. I feel we could have had more entities rationalized if that was the case. Funny enough, Louis, I have had this exact discussion with several of those bodies, like you have mentioned. Specifically within digital lending, I did speak to the MRD department and spoke to Bank of Uganda, spoke to the PDPO, spoke to the Financial Intelligence Authority, and I was asking the same questions. Why does a license holder have to go through all of these things? If you want to get a National Payment Systems license, but you have a component that has money lending, then of course you go to the MRD department. But also, there is also a provision within the National Payment Systems Act that you also have to get additional consent. Is it for certain products that would fall outside your traditional payment license structure or scheme. So their answer was that ultimately these licenses are not too expensive, and that the companies that operate within these spaces should still be able to get these licenses. 100% actually, I did discuss with them, with MRD in particular, and with BAU about a Twin Peaks model. That is one of the recommendations I gave to the digital lending sector, being that you have a regulator that focuses, you have within that system or framework, those are Twin Peaks, one focused on market conduct, the other one focused on the actual regulation. And so consumer protection, ETC, would fall under that perhaps market conduct, and then the regulation now handles the licensing, so that then you shorten the process. I think we are still learning. Our regulators are still learning. And I think the more that they interact with the private sector and practitioners like you on the ground, that is what will make it easier for them to be able to then have laws that are not making it difficult for our clients to operate. For you as a lawyer, I don't know why you're complaining, because you're getting money from all of those different licenses that you're going to be able to apply for. But that is from a more selfish perspective. I do agree with you 100%. I think that is what I'm saying, Luis, that it makes sense to definitely have the Twin Peaks model. It has worked in South Africa. But funny enough, also when I spoke to an association of digital lenders in South Africa, they didn't have many good things to talk about their Twin Peaks model. Specifically, I think because then once this entity, all these two entities are handling all of these things, you create a new problem of bureaucracy. Because now there are few people that are handling many applications, and sometimes maybe some things will get lost in translation. So they're saying that their system is not too efficient. And yet, if you spread out the licensing process across 2, 3, 4 different regulators, you find that Bank of Uganda will perhaps do something well, and maybe another regulator will not. Maybe then you have that checks and balances. But I think it still comes down to efficiency, and it does make sense for people to be able to have licenses from one body, or from at least a centralized body that then has desks where these people can be able to feed in and maybe give no objections, whatever it is. So I would think that the more that our industries grow, the short answer is that that's why they need to interact with us more. And again, that's why Uganda Law Society is important. Yeah. Because we are the ones that are supposed to be talking to these bodies and saying, look, you think that this is working, but we represent these clients, is what they are saying. And so definitely, I feel that is a job for Uganda Law Society, for us as a body of advocates to be the ones that are explaining to the regulators how things should work, and then making practical recommendations as to how they should be. The sandbox, you're not the first person to complain about it, specifically also how those laws are applied. I have my friends in Bank of Uganda, but I also have fought with them over the application of the law. You have a law, for example, the National Payment Systems Act does not stop someone from being able to, does not stop a foreign license holder from being able to apply for an NPS license. At least that was before the amendment. But at the time when the law came out, then we had issues where companies were coming in and registering as foreign companies, and then Bank of Uganda says, no. You must be able to incorporate a local subsidiary. This guy's like, yeah, but you should have told me this at the beginning, or the law is not saying that. So what I'm saying is that there is also still a disconnect between the law and the application of the law, or the regulator and how they apply these principles of law in that regard. In many respects, it now comes down to interpretation, but you find that the regulator will have more power. You know, which client of yours is going to be willing to take them to court to be able to define a particular aspect of law in that regard. But you are right, the sandbox does not have to be, actually, the sandbox was created for unlicensed operators, for them to be able to, for the regulator to be able to see which category of license applies to that particular client. So it should not be that a licensed operator is the one who operates or gets into a sandbox. If that is what is happening at the moment, I would think that is a wrong interpretation of the law. And again, these are issues that Uganda Law Society should be looking at in that regard. I think your first point was on NFTs, as well. No, your second point was also on NFTs and how there are more stringent requirements for Ugandan companies. Again, you know, if you have a legal system where intellectual property is not seen as something that is ingrained or is ubiquitous to any transaction, then it becomes difficult for people to take us seriously or to take our work seriously.
Sure.
So that's why we need to give more comfort to the public, to other stakeholders outside of Uganda, that there are mechanisms in place to be able to handle copyright infringement, and that it is something that is taken seriously in Uganda. Maybe that is when, so it is really a collective effort for us to be able to grow that particular industry. But I am glad that we do have a number of artists now that are going into NFTs or other versions of digital art that borrow from the technology that creates NFTs. And for many of these, yes, ultimately, that is what we had started with. Does the law stop someone from being able to recreate something physical if they're creating a digital version of it? The law as it stands is that if I create a digital version of something, I own copyright in it. Whether it is derived from something or not, it now becomes a dispute to determine whether there's direct copying or if there's infringement in that regard. And I feel that's where, as we keep making amendments to the law, it should be able to focus on that aspect. I think the last thing was your first point. I forget what your first point was.
I think you had done
spoke
with
about no, you had
non-virtual assets, which you have talked about. So.
No, it was about GitHub and about software developers being able to use these. I would say now it is open source, because once you have an AI application, it will create for you something seemingly proprietary. I'm using quotes for those that are not watching, but is it proprietary if it has been created by AI, which is also picking from other sources? So I would think that as lawyers, same thing with software developers, they must adapt.
Yeah.
I don't think we should be looking at copyright from the perspective of software that is proprietary. My view is that at the moment, there's no software that is entirely proprietary. It will become proprietary, or it is proprietary, if it then it is interoperable or connects to other systems or networks in ways that make it easy for the transfer of data. It is proprietary if it can have a component that would bring that software to life. You know, if someone creates a robot, that robot would only be effective if the software that runs it thinks like you. That's why AI is actually as big as it is, and that's why it is still possible to have more proprietary applications when it comes to how AI is used in the different sectors where it is used. So if I think about it from that perspective, we should be advising our clients not just to focus on the registration of copyright or patents for the software that they create, but rather what other rights are associated with that actual creation. You know, if I'm advising a client, what brand have they created? Do they have a distinguishable mark that can get trademark protection? Because ultimately then brand, if you're looking at brand protection, it has now expanded to focus on the getup and how that software interacts in a particular environment. That can also form part of the valuation of a particular brand. Now that is intellectual property. As I said, the other rights as well, maybe the copyright in how the system looks, how it functions, all of those can be incidental to the source code, which may not be proprietary, or you shouldn't waste time being able to go after someone, because I've said with copyright, you have to have that aspect of direct copying. So I think we should encourage our innovators to think about creating applications that would essentially have a utility model or a patent. That way it would be better to be able to protect them. Or number two, we focus on the ancillary rights that are associated with the creation of that system, so that the work is not only on the protection of the IP system as it has been created, but rather extends to these other rights that stem from or come from the creation or use of that system, and borrowing from other disciplines as well. Because, for example, if I create a system that would operate, let's say, in the coffee space, which is now a very popular space, but if that system is able to determine how to extract or to actually look at the flavor profiles of a particular coffee, then that can be borrowed when it comes to the registration of a geographical indication for those that are actually in that particular industry, because then now it makes it easier to be able to show the qualities of a particular product. So I think innovation needs to expand beyond registration of IP.
Yeah.
And that is really what I will end with, unless there is another question, that as an intellectual property practitioner, as a practitioner, your work should not only focus on registration. Like I've said, it should focus on commercialization. And when you look at commercialization, then you have a much wider net for you to be able to bill, for you to be able to have billable instructions, and also for your client to have value in as regards to how can they be able to make their IP work. How can you structure their IP in a way that it has value from the time they come to you to the point when they put it to the market in that regard. I think I've answered all of Luis's questions.
I will not try to dilute these very, very rich submissions of Ken. I also want to thank Louis for those very extensive comments. Maybe one for the road. I think we need to take this fight a bit to another level. You and me, Ken, you realize that whereas we talk about the possibility of billing for different licenses, I have had international clients give instructions, and they can't fathom when you start telling them there is this license, there is this license, there. I mean, it just baffles them. They don't understand it. So why? So I think, first of all, many of these fintechs and many of people in this industry are not local. They come and partner with local solutions for expansion. They leverage on each other. So I think we need to go an extra mile. As a firm, we actually wrote to the PS, put our complaint in writing, and put our proposal, and copied in the Minister for Finance, because all these are falling under that jurisdiction idea. We are yet to hear from him. But you also realize that there is also too much truncation, like you're saying. I mean, will you run to Ministry of ICT because that's where you're finding NITAU, that's where you're finding Data Protection Office, and then you run to BOU, and then, I mean, you can't. So I think for the clerical call here is that as the bar, we ought to move the offices that be by way of a write-up. And I pledge to follow this up with the relevant sector within the bar, so that we make a formal write-up to this. Otherwise, it's not nice. It's really not nice. Members, I can't stretch this any longer. This conversation has been so sweet that we even forgot about the time. When Ken came, I asked me, how long? I say 1 hour. And I'm not going to apologize for the 3 hours, literally. It has been a very, very rich conversation. Thank you very, very much for attending. The recording will be up. We expect that our studio people, the YouTube will be uploaded by close of business tomorrow. So check in, and you're able to have the video bit of Ken. You missed a lot of facial expressions here. He's so passionate about this industry, more especially when it comes to protecting the innovators. Ken, thank you really very, very much. And to the listeners, want to thank you for keeping with us, and we want to wish you a good night. And for the innovators, please, the clerical call is involve attorneys in these processes. You'll need them along the way to avoid making mistakes. It is not expensive. Like Kenya said, any serious practitioner in the intellectual property ecosystem knows that if you are an innovator who is a startup, he needs to give you a shoulder to that level when you are able to commercialize your product, and that's the level they are able to probably be able to make good benefit. Thank you very much, Ken, and thank you everybody for listening in. It has been Galantone, your host, and our beloved Kenneth Mohanji from KTA. Thank you and Good night.